Good morning. May it please the Court. I'm Marlene Reese on behalf of Carlos Rodriguez and Barbara Aloy.
You had a very good case for a while.
I'm sorry, Judge?
You had a very good case for a while.
I know, until April 3rd,
Yes.
I think. And certainly, and I filed that.
I think it was at 10:30 in the morning.
We obviously filed that as supplemental authority, and I certainly understand that.
Which we appreciate. It's
that
rare
is-
that both sides file a notice of supplemental authority that's directly on point, and you should be
But
commended
you
for
missed,
having done that.
you missed the supplemental authority of this on the same date or a week later, which affirmed with the same, pretty much the same parties, affirmed on the authority of the en banc opinion. Exactly.
and-
Soares, I think.
Judge, I don't recall if we filed that as a supplemental authority.
Well, in any
but I
event, there
certainly
was
remember seeing
there
it.
was
It's-
such a case. It was the same case.
It's going
with
downhill for us.
the same- just like we have a case later with the same dog that was before the Supreme Court of Florida. Here we have the same, I think we have the same public adjuster, if I'm not mistaken. We certainly have the same hurricane. We certainly have the same facts. And good luck to you, Ms.
Thank you, thank you, Judge.
Aside from that.
There is a point that I would like to make, though, with regard to the cases that are coming out and that began coming out in late 2011 and all through 2012. And that is that at the time of this summary judgment hearing, obviously, in retrospect, had the plaintiff had the opportunity of these cases that have now set out a particular standard for the opposing evidence, I would hope that at that point in time they would have been able to get sufficient.
But those cases are now affirmances. Other judges had done exactly the same thing and were eventually affirmed. You can't make that argument. And also the court said, we're going to grant summary judgment. If anything new happens, you can file a rehearing. You didn't.
We did not, Judge, and I certainly wish that we had. And
Well, if you had, you would have to have done so, as in every case, in good faith. And
well,
you would have to have something in good faith in support of it.
and frankly,
And perhaps the reason that you didn't do it is that you didn't have anything in good faith.
well, in
That you
fact,
thought that, and some people did for some limited period of time, that you were right.
in fact, Judge, excuse me, State Farm had subsequently deposed between the summary judgment and the date of trial. I just want to make this point. We didn't file them. State Farm filed them. In fact, there were depositions that, I'm sorry, that could have supported a motion for rehearing, but the fact of the matter
You
is,
didn't file one.
there was not one filed, Judge, and I can't dispute that. From a procedural standpoint, and the only argument that I have left, obviously, is from a procedural standpoint that the summary judgment hearing itself was not reasonably
That
noticed.
would be, actually, it's not a very good argument to begin with, but if it had anything to it, the judge says, if there's any problem, file a rehearing, and you didn't do it.
I can't disagree with the court. I can't disagree with the court. I think that if the court were to reverse and the summary judgment hearing could go forward now, the appropriate evidence could be obtained, but obviously it wasn't at the time.
No.
Thank you.
Thank you.
Thank you.
May it please the court, Carol Rockenbach on behalf of State Farm. Would I be snatching from
Yes.
the jaws?
Yes.
We would respectfully request this court to affirm the summary judgment below. Thank you very much.
Thank you.
And I cannot rebut that, Your Honor.
Nice to see you again.
Thank you.
Thank you.
Thank you both.